Well, good afternoon. I want to welcome you to the third in the series of lunchtime webinars presented by Ohio Life Sciences and I and my colleagues at Thompson Hine. I'm Tom Zych, a partner in Thompson Hine and co-chair of the firm's privacy and cybersecurity group. We've been pleased to work with Ohio Life Sciences on this webinar series and in general, but in this series, we have been presenting a number of quick lunchtime programs on hard hitting on key topics in front of mind in the legal and life sciences world. Hopefully providing information that is valuable to you as you plan your business in the changing landscape. We are proud to be both members and supporters of Ohio Life Sciences and look forward to our continued partnership as we go forward. Today, we have two topics to cover quickly and in a practical way. My colleague, Jim Fraser, will be presenting on FDA updates, and my other colleague here today, Marla Izbicky, will be presenting on privacy and data security developments that'll be of special importance to your business. So with that and nothing more, I'll turn it over to Jim.
Thanks, Tom. Can you hear me okay? Great. Welcome, everyone. My name is Jim Fraser. I'm a senior counsel in Thompson Hine's Washington, D.C. office. In addition to my private practice experience, I spent about 5 years as a associate chief counsel in the office of the chief counsel at FDA headquarters in Silver Spring, Maryland. So in that role, I did many things, but one of those things was defending the agency when the agency was sued by drug companies or medical device companies, and also represented the agency when the agency was bringing enforcement actions against regulated companies. The topic I'm going to cover today is FDA's proposed regulation that would make explicit that in vitro diagnostic products are medical devices under the Food, Drug, and Cosmetic Act, including when those products are manufactured in a laboratory. These are often called laboratory developed tests, or LDTs. And FDA has also proposed to phase out its quote unquote enforcement discretion approach with respect to LDTs. Now, first I want to note that even if your business is not one that manufactures medical devices or LDTs, this is a topic that really should be of interest to you. It's really fascinating. If FDA finalizes its plans to have this regulation, there's going to be legal challenges to the regulation, and this is going to be a case study in on the limits of FDA's authority. So it's not just relevant for medical devices; it's anything that's FDA related. So since 1976, the Food, Drug, and Cosmetic Act, which was passed by Congress, has defined medical device as including things such as an instrument, an implement, an in vitro agent, or similar article, which is intended for use in the diagnosis of disease. Now, the definition includes other things, but for our purposes today, that's the important part of the definition. So under the Food, Drug, and Cosmetic Act, if you manufacture a medical device, there are a lot of requirements that you have to follow. You have to register your facility with the FDA. You have to list your devices with the FDA every year. You have to follow current good manufacturing practice regulations for medical devices. For medical devices, those are referred to as the Quality System Regulation, or QSR. Those are incredibly complex regulations and really burdensome to follow. You have to report to the FDA anytime you receive reports of significant adverse events experienced by someone who used your medical device. And then depending on the complexity of the device, you may have to get pre-market authorization to even market your device, either through the 510K process, which is kind of for medium risk devices, or the pre-market approval process, the PMA process, which is for higher risk devices, and that is incredibly expensive, requires usually clinical trials, and takes a long time to go through. And failure to comply with any of these requirements subjects you to FDA enforcement action, which can range anywhere from a warning letter. The FDA can issue an injunction or have a court issue an injunction against you, which shuts down your operations. The FDA can seize the products, literally come into your facility and take them through federal marshals. And in extreme cases, FDA can bring criminal prosecutions against the company and high-level officials within the company. So many companies that manufacture in vitro diagnostic products, which are tests that doctors use, laboratory tests, tests for glucose, pregnancy tests, all sorts of tests that you're used to having, blood tests. Companies that manufacture those devices and sell those devices to healthcare facilities or sell them, through drugstores and things. Those are considered to be medical devices, and FDA has always said they're medical devices, and those companies have to jump through all those hoops that I just talked about. However, a lot of IVDs are actually manufactured and used solely in healthcare facilities. And include, for the larger facilities, it can include hundreds of different tests. And for many years, FDA has taken the position that although those products are medical devices, FDA will exercise what it calls enforcement discretion over the devices. I learned in my time at the FDA, I often tell people that if there's one phrase I heard more often than any other when I was at FDA, it's the term enforcement discretion, which FDA takes very seriously. And then what it means is FDA decides if and when it's actually going to enforce the Food, Drug, and Cosmetic Act. And there are a lot of situations for various reasons where FDA says we're going to exercise enforcement discretion, meaning although this product is subject to certain requirements, we are not going to enforce those for various reasons. And over the years, FDA said it exercised enforcement discretion over laboratory developed tests, these IVDs that are being manufactured and used solely within a healthcare facility, because there wasn't a huge concern over the safety of them. And it would be really burdensome to put those facilities, make them jump through all of these hoops. So fast forward on October 3rd of 2023, so just this year, FDA proposed its regulation, and the proposed regulation says we are clarifying that LDTs are in fact medical devices, and we are going to, over time, in various steps, phase out our enforcement discretion policy. So stage one, 1 year after we start the phase out, anybody who manufactures LDTs is going to have to start reporting any adverse events that it learns of to the FDA. That may sound like not a big deal. It is a big deal because you've got to actually put somebody in charge of that. You've got to have standard operating procedures. There's record keeping requirements. It's going to put a burden on facilities. At the 2-year point, LDT manufacturers will have to start registering their facilities with FDA and listing their devices. At the 3-year point, they're going to have to comply with the quality system regulations. As I said before, that is incredibly burdensome. But it requires you to write up and implement a whole host of standard operating procedures. You've got to hire people who, that's their job, is to make sure that the quality system regulations are being implemented. And that's an area where a lot of medical device manufacturers, when FDA does inspections of medical device manufacturing facilities, that's where a lot of medical device manufacturers have problems. And they end up getting warning letters or more significant enforcement action because they're not complying with those QSRs. And then at the 3.5-year point, FDA is going to start enforcing the pre-market review requirements for high-risk IVDs. So if it's which, as I said before, is the pre-market authorization requirement, which is hugely expensive, hugely time-consuming, very complex. And then at the 4-year policy, FDA will start enforcing all of the pre-market review requirements. So for less risky, what we call class 2 devices, you have to go through the 510K process, which isn't as onerous as the PMA process, but it's still a significant process. Now, This is for all agencies, not just the FDA, but when agencies propose a regulation, the proposed regulation is published in the Federal Register, which is a federal publication that comes out every business day of the year. And the public is given an opportunity to submit comments on the proposed regulation. And the notice and comment period has closed for this proposed regulation and the proposed new policy. And the FDA has received over 7,000 comments. And most of these are available on the federal docket. You can go in and look at them. The only reason something wouldn't get posted is if it contained confidential commercial information or trade secret information. But other than that, it all gets posted on a website called regulations.gov. So for example, I know that the Cleveland Clinic posted comments regarding this proposed rule, raising some problems that the Cleveland Clinic found with the rule and asking that if it go forward, it be revised significantly. When agencies get these comments, the law requires that they address the substantive comments, and this is all done behind the scenes. And then the draft of the final regulation is sent to the White House, to the Office of Management and Budget, OMB, which has the final say on whether this will go forward. Normally, that process of reviewing the comments for something as significant as this will take 2 or more years. It takes a long time because FDA wants to make sure that they, in writing, significantly address all of the comments and explain why those comments should not change what the FDA is planning to do. And a lot of these comments said this is just too burdensome. The FDA hasn't adequately assessed how burdensome this is going to be and how it's actually going to result in a decrease in the availability of these tests because manufacturers, healthcare facilities that manufacture these tests for their own use are not going to be able to bear the cost for all this. Comments also include the argument that under the Food, Drug, and Cosmetic Act, that laboratory developed tests do not meet the definition of medical device, and therefore FDA doesn't even have the authority to promulgate this regulation. So, like I said, normally it would take FDA years to deal with all those comments. FDA already sent this draft final rule to the Office of Management and Budget on March 1st of this year, meaning that they have gone into overdrive to try to get this out the door and finalized. One reason for that might be that there's a federal statute called the Congressional Review Act, which provides that Congress, on a simple majority vote and approval by the president, can overturn a federal agency regulation if it does so within 60 days of the regulation being adopted. And so when you get close to an election, and there may be a change in parties or change in president, agencies get nervous because it happens quite frequently, where the new administration or the new Congress comes in and they just overturn the regulation and that's it. And I think the law actually prohibits the agency from reintroducing the regulation for a certain period of time. I'm not positive about that, but I think that's what the statute says. And I can tell you, I worked in the FDA from August of 2016 to August of 2021. So I was there for the Obama transition to the Trump transition and from the Trump transition to the Biden transition. And I can tell you that the Trump administration did not want FDA regulating laboratory developed tests. So FDA, I'm surmising that that's why this is moving along so quickly. But in any event, if and when this gets finalized, like I said before, there are likely to be legal challenges to the rule, to the regulation. And under the Administrative Procedure Act, when the FDA or any agency implements a regulation, members of the public who are adversely affected by that regulation can sue and can make various arguments, one of which is the agency doesn't even have the authority to do this. The agency is interpreting the statute wrong. And you may have heard reports in the last few months about the Supreme Court deciding whether it's going to reverse the Chevron doctrine. This is an example of that. Under the Chevron doctrine, if a statute is ambiguous, then courts will defer to an agency's interpretation of the statute so long as that interpretation is reasonable, even if the court thinks there's a better interpretation. But if the Chevron doctrine is reversed, then courts will just say, the court's just going to determine what the best interpretation is, and that will be the interpretation. And when you do a regulation, you have to take industry's the burdens and reliance interest into account and make sure those are adequately dealt with. So we can expect that if this is finalized, there will be challenges. And when I said this is important for people, even if you're not in the medical device industry, that goes for anything. So when you disagree with the FDA about something, FDA often gets sued and often loses. For example, on issues like orphan drug designation or drug exclusivity decisions is one area where FDA has a lot of issues. So I'm up against my time. Obviously, if anybody had questions, they can submit them in the chat, and I think we're going to deal with them at the end, if that's correct, Tom. You're still on mute, Tom.
Reiterate, Jim, thank you. I just want to reiterate what you said, that when we watch the FDA in action, it's not just a limited subject matter that may be revealed to us. So we appreciate that. And I'll say this now, we'll read it again, that we'll provide contact information for both Jim and Marla if you want to talk with them offline or otherwise, feel free to do so. So Marla, it's your turn, and you're going to enlighten us on privacy developments.
Absolutely. So my name is Marla Izbicky. I'm counsel here in Thompson Hine's Chicago office, and I focus on data privacy and cybersecurity and work closely, of course, with Tom. Today, I'm going to be explaining to you the latest evolution in data privacy laws across the country, which is the Washington My Health, My Data Act. This act is unlike others, where it focuses specifically on consumer health data. The original authors of the act explained that this was inspired in response to the Supreme Court Dobbs decision, a fear that there's a gap between current healthcare privacy laws and how healthcare data and healthcare-like data could be used against a consumer. It's important in the life sciences world because it makes us take a step back and evaluate beyond PHI what other consumer health data might we be collecting. The Act looks at two very important components: consent and necessity of data. It has a broad-reaching definition of consumer health data, as well as what applicable entities it applies to and who consumers are. However, it has very strict requirements, which can make compliance rather tricky. One of the biggest risks out of this law for noncompliance is its private right of action. So only a handful of data privacy laws across the country provide for a private right of action, the right to sue by a consumer directly the company. This is one of those acts, which means any lawsuit, including a class action lawsuit, could be brought if a consumer believes that their rights were violated under the act. Today, I'll be going over what consumer health data is, what relevant exclusions might apply to us in the life sciences, what consumer rights must be afforded, and what obligations are placed on us as companies and organizations. The first question with any data privacy law is, who does it apply to? Who is it protecting? Often we see that a consumer under an act is defined as a resident of that given state. The Washington My Health, My Data Act is slightly different in that it applies not only to residents of Washington, but to any person's data who is processed or used in Washington. Essentially, if your company touches Washington, this act could apply. Consumer health data is a definition that is being largely discussed as it's somewhat ambiguous and unclear. Because of that, the ambiguity could lead to greater risk and exposure. But the Act specifically defines it as personal health information that is linked or could be reasonably linkable to a consumer that identifies the consumer's past, present, or future physical or mental health status. In other words, as opposed to personal health information, which we understand from HIPAA, this information is derived or extrapolated from non-health information. An example could be a cookie that's collected by an advertiser on an adverse event reporting. So the fact that the user is on that website may not in itself be health data, but you can extrapolate that they had an adverse reaction to a specific health condition, therefore making it consumer health data. As life sciences companies, we always ask, well, are there exclusions for the work that we do, research and the sort? Yes, there are. Like many other data privacy laws, certain federal preemption laws apply. Any data that's otherwise regulated by the HIPAA or HIPAA High Tech, as well as the Gramm-Leach-Bliley Act, Fair Credit Reporting Act, and FERPA, the Federal Education Rights and Privacy Act, that data is not also then subject to the Washington Act. Additionally, especially for life sciences, the Washington medical records laws, any federal research laws, and any clinical trial laws also are not then subject to the Washington My Health, My Data Act. However, it's important to understand that this is not at an entity level. If your entity is compliant with HIPAA, that does not mean that the data that you process may not still be applicable under the Consumer Health Data. Consumer rights, consumer control is always a focus of data privacy laws. In this case, consent, specifically double consent, is a priority of the Washington Act. When I say double consent, I mean that there must be two separate and distinct instances where consent, active consent, is gained from your consumer. The first is when collection of any consumer health data is taken, and the second is when any sharing or sale of that health data occurs. These two consents cannot be combined into one, and they cannot be combined with other areas of consent. It must be made clear that this is consumer health data consent and include links to a specific consumer health data privacy policy, which I'll be discussing in just a few moments. Now, consent and active consent are also an area that we try to understand. Is active consent merely moving forward with using a website or a companion app? Or is active consent have to be clicking a box? Does it have to be typing in personal information to verify, such as the last four of your phone number? In this case, it is considered active opt-in, meaning passive actions would not be enough. Similarly, having small text or a button somewhere that explains that you're having consumer health data that's pretty hard to see or to read or notice is there, also not okay. That's something that we call dark patterns. It's text, color, font, multiple levels of click-throughs to enable a consumer to understand they're giving consent or what rights are afforded to them. Unfortunately, we're seeing more and more that that's not sufficient. Rather, affirmative opt-in is where a consumer takes an action. So if there's a box, it's not already checked. They must check it and then click, I consent to you collecting this information. Then later, sharing, which under the Act is defined by any disclosure of data, must also get consent, where again, the consumer clicks or swipes or signs, I'm consenting to you sharing my data. In California, sharing data, which was one of the first times we see this share versus sold concept, was limited greatly in consent for behavioral advertising. So there, the consent was if you are sharing the data for behavioral advertising purposes, then you must give the consumer consent options. Here, there's no such carve out. Any consumer health data, not just which may be used for behavioral advertising, would be relevant, and therefore you'd need consent. Consent, however, is not needed if you are either collecting or sharing it for the purpose the consumer has provided it to you for, such as getting a service or buying a product. As an example, if you have a companion app to a drug and you have a consumer who is logged in and looking for articles that may be relevant to general heart health, well, you're collecting the information from them that they are interested in heart health, which could be considered consumer health data. You can extrapolate, maybe they are worried about heart health and heart conditions, but you're using it to specifically provide back to them the information they requested. In that case, consent isn't needed. However, if we go back to our original example of an advertiser's cookie collecting when adverse event reporting is occurring, that is not being used for the purpose the consumer wants it to be. In that case, you're taking consumer health data that an adverse event occurred, and you're using it for an advertiser to be able to custom tailor advertisements down the road. In that case, we would need specific consent. Consent in the case of sale of data, which is for monetary or any other valuable consideration, is even more stringent. That consent must describe that the data being sold, what the data is that's being sold, why it's being sold, and then identify both name and contact information for who's purchasing it. Also, on top of that information, you then must also list why the purchaser is buying the data and what they plan to use it for. If once you've gotten consent for the sale of data, you are able to move forward, that consent is only good for 1 year, meaning you must have appropriate policies and procedures in place to ensure that annual renewals of consent occur in order to continue to sell that consumer health data. Another important part of the Washington My Health, My Data Act is the absolute right to data deletion, where in other cases we see that a company may refuse a request for data deletion, such as for enforcing contractual rights. The Washington Act explains that the right to data deletion for a verified consumer is absolute. There can be no denial of that request. Obligations on our end, most specifically that privacy policy I talked about. A consumer health data privacy policy must be drafted and listed on the website with a specific and separate link on a homepage. It can't include any other information other than what's required under the My Health, My Data Act, which means it can't be combined as just another section under your privacy policy or with other terms. It must be its own consumer health data privacy policy, which explains both what the consumer's rights are, as well as exactly how they can exercise it. Another unique component and obligation for life sciences providers is geofencing prohibition. This prohibition will be going into effect this July. It says that no geofence can exist around a place that provides in-person healthcare services. Going back to the original inspiration of the Dobbs decision, this means if a center provides reproductive healthcare, then a geofence can't exist around it that might collect, identify, or track an individual who enters that perimeter. As we can see, the potential touch points that Washington's law could reach for various types of data that could be extrapolated is broad, but the requirements are very strict, making compliance tricky and one you might need to take a more careful look at. I believe, and we believe, that this is only the first of many health privacy laws that are going to be springing up across the country. Just as HIPAA revolutionized the way that we look at PHI, so too could this type of consumer health data law revolutionize the way we look at anything that touches or could inform healthcare about a consumer, such as our companion apps, our adverse reporting, or partnering with marketing and sales. Additionally, the risk of that private litigation, the potential for class action level damages, could spur a wave of litigation like we've seen with other similar acts, like in Illinois, the Biophysical Information Privacy Act. It leads to certain plaintiffs finding a lot of people and going after one company, potentially resulting in catastrophic damages. For this reason, I encourage each of you and your relevant stakeholders to take a look at what other data besides PHI might you be collecting, and do you have the proper policies and procedures in place to ensure compliance?
Marla, thank you. I want to echo something that this is just the latest and what we think will be a continuing series of regulatory attention. You mentioned post-Dobbs being one factor that's raises the political stakes around this, and generally the awareness of what may be gathered about you, not in the doctor's office and not in the hospital in the standard medical service provider field, but we're wearing health apps, we're on our watches and the like. So I think we're going to have to watch these developments very closely over time. So thank you for that, and thank you, Jim, for the timely update on FDA activity. So that is our halftime. That is our lunchtime seminar webinar today. Again, we thank you for attending, and we'll be circulating information on how you can contact today's speakers if you want to follow up on anything they've talked about or their subject matter in general. We've recorded this. We'll work with Ohio Life Sciences to make this available online and on demand, so tell friends that this will be available. And we thank you. And the fourth and last in our series will be on April 3rd, when we'll be talking about licensing, IT contracting, and intellectual property issues. So again, we thank you for your attendance, and we hope you enjoy the rest of the day. Be well.